Wallenberg Centre for Human Rights. We're an international human rights organization anchored in the pursuit of international justice and led by our chair, the Honourable Irwin Cotler, who was a former Justice Minister of Canada. And he sets a motto for all of us that nothing is impossible until you try it. And we've kind of followed his lead in terms of all our work. And we have to get creative in terms of how we enforce the law. So we see our role as international lawyers and a human rights organization in finding those innovative ways to play our part in responding to atrocity crimes. We've adopted an approach that focuses on entity and state responsibility for enabling and driving atrocities. So we're looking at all the various factors that allow warring parties in conflict or oppressive regimes to commit atrocities, and we try and target those sources of their capacity to carry out atrocities. A way to term this is sort of conflict disruption advocacy or conflict disruption litigation, and it's an emerging field, and we're hoping that we can supplement and complement the existing mechanisms at the international level to close the impunity gap for entities and states that are evading accountability by finding ways to bring them either to court or to expose their role in facilitating and fueling atrocities. Over the past few years, we've sort of developed a model for issuing legal findings on atrocity situations by collaborating with subject matter experts, international law experts, open source intelligence investigators, so that we can issue findings in a timely manner and then use those findings to advance policy and outcomes at the international law level. Our most recent report on breaches of the Genocide Convention in Sudan, for instance, we then used that report as a platform to establish an accountability task force for Sudan. And we've grown since we've established this task force. We started out with human rights organizations focused on Sudan, investigators looking specifically at the illicit networks that are funding and supporting perpetrators and parties to the conflicts, and lawyers who are specializing in various strategic litigation methods. One of the major target forums for us has been the International Court of Justice. That's one of the main legal mechanisms we've been pursuing, and that's involved a lot of building the factual record, building the legal case, and also recruiting a state to take on the case, as the International Court of Justice is based on state applicants. We're also looking into legal avenues to bring corporations to court who are also complicit in the atrocity crimes in Sudan. So those are some of the various mechanisms. We were a bit caught off guard when Sudan brought this case to the ICJ, and we were even more distraught when we saw the sparse nature of the application that was brought. And immediately we sort of understood that this case was not necessarily filed with the necessary preparation or intention of winning on the merits down the road. And so we've avoided working with Sudan as a state because right now it's being represented by the Sudan armed forces, and so we've avoided any sort of interactions with them. But we intend to bring a state with a cleaner record that can then plead all the violations that a state like the United Arab Emirates, for instance, is responsible for. And our intention would be to get provisional measures that would serve as an independent judicial order demanding, a halt to the transfer of weapons to the RSF and calling out accomplice type liability for supporting the RSF in its ethnic cleansing and genocide and mass atrocity crimes. All the forms of existing litigation to respond to atrocity crimes are really far too slow, and everyone knows that the wheels of justice are far too slow. And so as we're watching massacres unfold, sieges on cities that are driving starvation on unprecedented levels, and a humanitarian catastrophe which we haven't seen in decades, we feel the constant need and responsibility to act more timely. And so that's why we're also producing reports where we are establishing legal grounds that can then be taken up by state actors or in other legal proceedings to establish the liability of the warring parties and their supporters. In these contexts, the challenges to collecting evidence are well known, and especially in a situation like Sudan, where even the UN fact-finding mission doesn't have access to the conflict zones, we're relying on open source intelligence investigators, and we're capitalizing on the technology that we have, and we're trying to harness the available information that's out there and work with open source intelligence or remote sensing experts in order to take that evidence and derive legal findings from that. We're using reasonable grounds to believe or clear and convincing evidence, and then in consultation with our other international law experts, and we are agreeing that this available evidence is enough to conclude that, for instance, the RSF and the SAP have committed war crimes or crimes against humanity, and that states like the United Arab Emirates or regional states bear responsibility for complicity in crimes against humanity, genocide, or failure to prevent. To my knowledge, this is the first time this has been tested internationally in terms of our focus on really zeroing in on state and entity liability and trying to disrupt conflict by tapping into our diverse expertise. So we're increasingly diversifying the options for strategic litigation beyond the ICJ to work with our partners to identify which financial institutions, which arms manufacturers, where are these companies or based that are facilitating the flow of arms and the financing of the parties, and how to identify where the best venue would be to bring a potential case, and what are the advantages and disadvantages, taking into account the length and costs of litigation, the willingness of a victim group to join. It's something new, and we really believe that this is going to be effective in the future for not only Sudan, but we're hoping that this model can be used in various contexts, continue our work, and bring successful cases that can at least impose costs on the perpetrators and enablers so that they don't escape scot-free, and continue to benefit from the violence on the ground.